I'd like you to put your hands together for Prof de Costa.
Thank you very much, Jenna. First of all, I'd like to congratulate the organisers of the conference on having put together such a fantastic meeting and thank them for inviting me along. I must say that I felt a little apprehensive as a mere medical practitioner at the thought of talking about law to a lot of lawyers and future lawyers. So I will disclose to you that I have given birth to 2 lawyers. And I also have a third daughter who is known to some of you as a Monash law student, but she is currently on the Malaysia campus of Monash. And I am going to talk about abortion law. As a practitioner, I perform abortion as part of my clinical practice in Cairns. And the first thing to say about abortion law is that it is mostly state law. And originally, at the time the states were being established, at the time of federation, laws across states were very similar. Abortion law was put into the criminal legislation, the criminal... sorry, we've gone too far there. The Criminal Codes and Crimes Acts of the individual states and territories contained abortion law. And then during the 20th century, with advances in medical and surgical practice and changes in social attitudes to abortion, there have been reforms and indeed decriminalisation across states, but it's been very uneven and there's been no coordination. So there are now wide differences in abortion law across Australia, and this means that there are big differences in access to abortion for Australian women depending on where they live. Now, there is one aspect of Commonwealth law which does impact on abortion, and that is the legislation concerning the Therapeutic Goods Administration, which is the TGA, which regulates the import and use and indeed manufacture of drugs in Australia. And so it oversees the use of those drugs that since the 1980s have been used for what is called medical abortion, which means induced abortion under medical supervision using drugs for the purpose rather than surgery. And there are 3 of these drugs used now in Australia, misoprostol and gemiprost, which are widely available across the country and haven't been controversial. But also mifepristone, which is probably better known to you as RU486, which is widely recognised overseas and indeed now here as being the most effective drug for medical abortion, and it is also used with that other drug, which I've just told you about, misoprostol. RU486 has been more controversial in Australia than anywhere else in the world, and this is due to the Machiavellian machinations of Senator Brian Harradine, who in 1996 made a deal with John Howard. Harradine would support the privatisation of Telstra if Howard would pass the Harradine Amendment, which prohibited the import or use of RU486 into Australia without the special permission of the Federal Minister for Health. And this was obviously so onerous that nobody ever actually asked the Minister for Health. And the effect was to deprive Australian women of this drug, but also of the knowledge that women overseas were gaining of the effectiveness and safety and acceptability of medical abortion. Now, this changed in 2006 when 4 women senators, cross-party, brought a private member's bill to the Senate, which then passed through the House of Representatives, and the Harradine Amendment was overturned, and some of you may remember that. But this simply meant that the drug could be treated like any other drug, and it was required, a drug company was required to make an application to the TGA to have the drug considered. And 5 years later, this has still not happened, partly because Australia is a fairly small market, but also because the drug has been so controversial here and drug companies are commercial entities. We therefore looked at ways around this and settled upon some legislation, which up to that point had not been very widely used, the authorised prescriber legislation. And this has nothing to do with abortion. It is legislation which means that individual doctors, if they have a patient whom they feel would benefit from a drug which is available legally overseas but isn't available here in Australia, can make an application to the TGA to import that drug and use it in their own practice. And in Cairns, Dr. Michael Garrett and I in 2006 made such an application to the TGA to use mifepristone. And initially the application process was very cumbersome, and the TGA were very careful about their decision, but they were helpful, and they gave us, we were the first to get approval to use mifepristone in this way. And since then, it has become a much more streamlined process, and more than 90 doctors across Australia can now use it, but only in their own practice. So you still can't get RU486 from your local GP or in your local pharmacy. So what we need is approval to a drug company to import and market mifepristone in Australia. This will greatly simplify the legal situation of the drug and greatly improve access to medical abortion for women across the country. And I am confident that this will happen by the end of this year. Now, going back to the state law, I'm going to start with the worst states and work up. Which happens to be my own state of Queensland. And since I'm going to talk to you about the Leach and Brennan case, it's important to actually look at the wording of the Queensland Criminal Code with regard to abortion. It has not changed since 1899. Any person, the first bit, section 224, refers to a person performing an abortion. Anybody who, with intent to procure the miscarriage of a woman, whether she is or is not with child, because in 1899 there were no convenient home pregnancy tests, administers to her unlawfully or causes her to take any poison or any noxious thing, remember those words, noxious thing, or uses force or any other means whatever, is guilty of the crime of abortion and is liable to imprisonment for 14 years. Section 225, you'll see, has exactly the same wording, but it applies in this case to the woman. Again, noxious thing, force, any other means, and so on. And this is the section which was used in 2009 to charge Tegan Leach in Cairns. And section 226 applies to any person who assists with the abortion in any way, procures any item or uses force or assists in any way with the abortion. And this is the section which was used to charge Tegan Leach's partner, Sergi Brennan, in 2009. Doesn't seem to be wanting to move on. So there is a defence if you are charged with one of these sections, and this is section 282. And that had remained exactly the same from 1899 till 2009 in September. And it was really directed towards a doctor who performed an abortion who could perform a surgical operation, because there was no medical abortion in 1899. It was restricted to surgical procedures. And the doctor could do this for the preservation of the mother's life if the operation was reasonable. So this was extremely restrictive. Now, as a result of the charges against Leach and Brennan in 2009, in September of that year, the Queensland Parliament amended section 282 to cover medical abortion as well, but they didn't liberalise the law in any other way. And the effect was actually the reverse to what we really wanted, which was to make doctors and health administrators, especially in the public sector, much more aware of what abortion law said. And it has actually reduced women's access to abortion in the public sector in Queensland, especially late medical abortion for severe fetal abnormality. And there are now, every week, Queensland women who have the diagnosis of a severe fetal abnormality made, who are then told, oh, sorry, we can't perform an abortion for you, you'll have to go to Victoria. Now, this law, I just wanted to point out to you, was very similar in 1899 to the English Offences Against the Person Act, which formed the basis of all state law at that time. And you'll see the wording is very similar, unlawfully procuring the miscarriage, whether the woman is with child or not. So the wording of Queensland law is almost identical to legislation which dates back 150 years, even though medical practice and society have moved on in that time. And the rationale for the criminalisation of abortion in the middle of the 19th century, prior to that, abortion had not been considered to be particularly criminal or particularly sinful. It was to protect women from unsafe backstreet abortion, but of course it did not do that. And in the 21st century, we know that the best way to do this is to provide safe, legal, accessible abortion services, accessible contraceptive services, and information about contraception, and not enforcing pregnancy on reluctant women. Now, we're coming slightly up the scale now. New South Wales, however, still has abortion in the Crimes Act, with quite similar wording to the Queensland Criminal Code, but it has been liberalised by case law, especially, first of all, the Manhattan judgment, which I'm going to talk about a bit more in a moment, of 1969, which extended the reasons for which a doctor could defend himself or herself when performing an abortion to the physical or mental health of the woman. And this was further extended by the Levine judgment in New South Wales in 1972 and by a judgment from Michael Kirby in 1994, which also took into account the social and economic situation of the woman at the time, but also in the future. So the actual practice and accessibility of abortion in New South Wales is much greater than, or much more extensive than it is in Queensland. Tasmania still has abortion in the criminal code, but it has been amended in 2001. But it does recognise that abortion can be legally justified if certified by 2 doctors, and those doctors can take into account any matter that they think is relevant. However, access to abortion is still restricted in Tasmania, and there still is abortion tourism from Tasmania to Victoria. Moving further up the scale, we have Western Australia. In 1998, 2 doctors were prosecuted for performing an abortion. As a result, there was a public outcry and a change to the legislation. There's a big difference now in Western Australia between abortion before 20 weeks, when it is very much the woman's decision. She needs to give informed consent. There are still the clauses about risks to her health, physical or mental, but she can also simply choose an abortion once she is well informed. After 20 weeks, however, 2 medical practitioners from a panel of 6 appointed by the Minister for Health must agree that the woman's condition or if she has a severe fetal abnormality, the fetus, there is a serious condition justifying the abortion. And only about 0.5% of abortions in Western Australia are performed after 20 weeks. And so there is some abortion tourism at that stage from Western Australia to Victoria. Better still is South Australia, who amended their law first of all in 1935 and then in 1969. Now, abortion is still in the criminal law of South Australia, but it is really quite liberal. There must be either maternal health or fetal disability grounds. 2 doctors must agree that the abortion is indicated. It must be done by 28 weeks. Interestingly, there you can see that 1.5% of abortions in South Australia are late, and that is probably the real figure for women who have major medical grounds or there is severe fetal abnormality who are requesting abortion after 20 weeks. It's not a common event. The South Australians take a very liberal approach to interpreting their law, and they provide abortion in the public sector, both in the public hospitals and in public clinics. There is, however, a 2-month residency requirement for an abortion in South Australia, so there's no abortion tourism to South Australia.